After her mother passed away, the county demanded $159,000 from her estate for past care services, but the care was minimal, and now she's in court because the amount doesn't make sense.
Your Honor, after my mother passed away, I received a notice from the county claiming $159,000 for in-home care services from 2015. The care in question was 2 to 3 hours a day, 3 times a week for less than a year. That level of service does not reasonably support a claim of this size. I requested an itemized bill, but none has been provided to justify the amount.
Your Honor, the claim originates from services provided under the Alternative Care Program. The county paid third-party providers for personal care assistance. Personal care assistance program. The county paid third-party providers for personal care assistance. Under state law, those costs are recoverable from the estate after the recipient's passing. The total reflects payments made at the time, including administrative and service-related expenses.
Your Honor, there is no documentation showing how this total was calculated. My mother only received limited assistance during recovery from surgery. She also reported issues with the caregiver and terminated the service early.
Has the county provided a full itemized accounting of the claimed amount?
Your Honor, full itemization has not yet been submitted to the court. The claim is based on internal records, but a detailed breakdown is still being compiled.
A lien of $159,000 requires clear, itemized proof of services rendered and payments made. No such documentation has been presented. Without verifiable records, this court cannot determine that the amount is accurate or lawful. Claim is denied. The lien is dismissed in full. The estate may proceed without paying this claim.
The county cut down his apple orchard from 1961 to expand a road. The road was later built through a neighbor's field. The orchard was destroyed for nothing. But watch the moment when the judge opens the road department's technical report.
My father planted this orchard in 1961, 63 years ago. I sold apples at the farmer's market every summer. The county came and said they needed to widen the road. Your orchard is in the way. I refused. They took the land through eminent domain. Bulldozers arrived and cut down all 80 trees in a single day. Some of those trees were 60 years old. Then I looked and saw the road being built through my neighbor's field, half a mile away from my orchard. My orchard was destroyed for nothing.
The taking was conducted lawfully for transportation infrastructure purposes. The route change was caused by technical factors identified during engineering studies after construction began. Compensation of $12,000 was calculated based on the assessed value of the vegetation. The county acted within the law.
I am opening the road department's technical report from March 2023. Page 8, the route through the neighboring field was determined to be technically preferable and more cost-effective. Date of the report 3 months before the orchard was cut down. The county knew it would build through the neighbor's field, and yet it still destroyed 80 apple trees that were 60 years old. $12,000 for an orchard that fed a family for 3 generations is an insult. The county will pay $180,000 for the orchard, $120,000 for lost income, and $100,000 in punitive damages. Total, $400,000.
He stored a boat in his backyard in Florida. The county charged him a harbor fee, even though it never touched the water, and threatened to fine him for storage. But the county made a big mistake.
Lawson keeps a registered boat on his property. Under county rules, boats that can be used on the water are subject to that fee. It helps pay for marina and waterway maintenance, and it's applied the same way to everyone in the county.
Yeah, the boat hasn't moved in 4 years. The engine shot. It's just sitting on blocks in my yard. I'm not using the marina. I'm not using the water. It's not even safe to launch. I'm just storing it on my own land like any other thing I own.
So let me get this straight. You charged him a harbor fee for a boat that's never even been in the water? No launch, no dock, no marina access? What exactly is the county doing for him here? Refund the fee.
A neighbor kicked the door of a vintage 1964 Aston Martin DB5. The classic car was worth hundreds of thousands of dollars, but the neighbor claimed it was just a small accident.
No, I already told them twice. If they can't handle one simple pickup, what's the point? Yeah, well, maybe. You know what? Forget it. You gotta be kidding me.
So the case ended up in court.
Your Honor, that vehicle is a fully restored 1964 Aston Martin DB5. I parked it in my driveway that afternoon. The security camera clearly shows my neighbor kicking the door while walking past the car.
I was walking past the driveway while talking on my phone, and my foot slipped near the curb. I accidentally hit the door with my foot. I didn't think it would cause any serious damage.
That is a rare vintage vehicle, and the footage clearly shows you kicking the door. Whether you were angry or careless, you damaged someone else's property. You are responsible for the repair costs.
The courtroom went silent after the judge spoke. The neighbor was ordered to pay the full repair costs for the damaged door. If you like the judge's statement, like and subscribe for more courtroom justice.
You flooded his entire home.
He drilled straight into his neighbor's water tank. Water burst out instantly under pressure. Within minutes, it reached inside the house. And what the judge said next shocked everyone.
Your Honor, I drilled into the tank because it was leaking onto my property. I believed releasing the pressure would stop the issue affecting my side.
I did not expect the water to spread that quickly or cause major damage. There was no intention to flood the house or cause serious harm.
Your Honor, water flooded into my house within minutes after he drilled the tank.
The water spread through the entire ground floor and damaged everything inside. Furniture, electronics, and belongings were completely destroyed by the flooding. This caused severe damage and made the house temporarily unlivable.
A deliberate action caused extensive flooding and property damage.
Why did you take direct action instead of reporting the issue properly?
I acted immediately without thinking about the consequences of my actions.
You flooded his entire home.
You are liable for damages and must compensate for all losses caused.
If you think justice was served, like and subscribe for more courtroom stories.